There's a knock at your door. You open it. Two men in plain clothes show their badges. We're from ICE. We just need to verify a few things. Can we come in for a second? And what you say in the next 10 seconds determines everything. Every single day, people across this country open their doors a little wider, answer one question, hand over one document, and unknowingly hand federal agents the legal permission to take them or someone they love into custody. Not because ICE had a court order, not because a judge signed anything, but because of one word. Sure, that one word, consent, is the most powerful legal tool immigration enforcement has, and most people give it away without ever realizing it. Here's what almost nobody tells you. The constitutional rights that protect you during an ICE encounter are the same rights that protect every person on American soil, not just citizens, not just green card holders. Every person, regardless of immigration status. Because the Fourth and Fifth Amendments say the people and persons, not citizens. Federal courts have consistently interpreted those words broadly, but those rights only protect you if you actually invoke them. Staying silent isn't always enough. Opening the door just to talk through it may not be enough. Assuming the encounter is over when it isn't, not enough. I've spent years analyzing immigration enforcement law and reviewing constitutional cases. I've studied the Supreme Court rulings, the internal ICE training documents, and the legal frameworks that govern what agents can and cannot do. And I've identified 4 critical mistakes people make the moment they hear, "We just need to verify," and the exact phrases that protect you. Miss one phrase, and you may hand ICE permission they don't legally have. Use all 4, and you've done everything the Constitution allows you to do to protect yourself. Let's break them down. Mistake 1, opening the door and letting them in. The mistake. There's a knock. You open the door. The agent says calmly, "We're just here to verify your identity. Can we step inside for a moment?" You don't want to seem difficult. You open the door wider. They walk in. You just gave consent. The scenario. It's early morning. A knock at the door. You open it. 2 men say they're ICE agents. They say they're investigating an unrelated matter, a neighbor, a package, an identity issue. They seem friendly. We just need a minute inside. You step back. They step forward. The legal reality. The Fourth Amendment to the United States Constitution guarantees the right of all people to be secure in their homes against unreasonable searches and seizures. The Supreme Court made this explicit in Payton v. New York, 1980, ruling that absent an emergency, the government cannot enter a person's home without a judicial warrant or voluntary consent. Here is the critical distinction that changes everything. ICE agents almost never have a judicial warrant, a warrant signed by a federal judge or magistrate. What they typically carry is something called an administrative warrant, specifically a Form I-205. This document is signed by an ICE official, not a judge. According to the Federal Law Enforcement Training Center's own training materials, an administrative removal warrant does not authorize ICE agents to enter a home. Their own instructors stated clearly in published training, if ICE does not obtain consent to enter the home, the officer has no legal authority to enter the home pursuant to that removal warrant. So when ICE knocks and asks to come in, they are asking because they need your permission. Why people do it? People open the door because they think refusing will make things worse. They think cooperating means safety. They think an agent who shows a badge must have the right to enter. None of that is legally true. The correct move. Here is line 1. Do not open the door fully. Speak through the closed door. Or, if your door has a peephole or you can crack a window, use that. Stay inside and say clearly, "I do not consent to you entering my home." Then immediately ask, "Do you have a judicial warrant signed by a judge?" If they say yes, ask them to slide it under the door. Look for the judge's signature and the court's name. If it is a Form I-205, the ICE administrative document, that is not a judicial warrant. You are not required to open the door. If they say no, repeat, "I do not consent to you entering my home." You do not need to explain yourself. You do not need to argue. You are exercising a constitutional right that applies to every person inside the United States, regardless of immigration status. Courts have consistently held, including at the federal district court level, that undocumented immigrants retain the same Fourth Amendment protections as citizens when it comes to their homes. The body cam footage, if there is one, will show you exercised your rights calmly and lawfully. That matters. Bottom line, never open the door fully and never invite ICE inside without first asking whether they have a judicial warrant signed by a judge. Without consent or that warrant, they cannot legally enter. Mistake 2, answering questions about your status, birthplace, or immigration history. The mistake. The agent is at your door. You didn't let them in, but now they're asking questions through the door or on the street. Where were you born? What's your immigration status? Are you a citizen? You answer because you think honesty helps. You think if you explain your situation, they'll leave you alone. Your answer just became evidence. The scenario. You're on your way to your car in the morning. An agent approaches on the sidewalk. Excuse me, we just need to verify a few things. Where were you born? You answer. And your status? You explain. The conversation goes on for 4 minutes. By the end, you've given them your country of origin, confirmed you entered on a specific visa, and mentioned that your visa expired. Every one of those answers is now in their notes, and every one can be used in immigration proceedings against you. The legal reality. The Fifth Amendment protects all persons, not just citizens, from self-incrimination. The Supreme Court made this clear in Matthews v. Diaz, 1976, holding that every person present in the United States, even one whose presence in this country is unlawful, involuntary, or transitory, is entitled to constitutional protection. Miranda v. Arizona, 1966, confirmed the Fifth Amendment applies regardless of citizenship status. Your immigration status, birthplace, how you entered the country, when your visa expired. Every one of these answers could be used against you in removal proceedings. You are under no legal obligation to answer any of them. Why people do it. People think that cooperating will show good faith. They think that if they have nothing to hide, answering is harmless. But ICE agents are investigators. Just like a police officer at a traffic stop, they are not there to help you. They are gathering information. Every answer you give is a piece of a case. Agent psychology. Agents are trained to make verification questions feel casual and administrative, not interrogative. We just need to confirm a few details. Sounds routine. It is not. It is evidence collection. And once you've answered the first question, the second feels just as natural, and the third. Each answer builds on the last, and by the end of the conversation, you've constructed a narrative that can be used directly against you in removal proceedings. The phrase, "we just need to verify," is tactically designed to lower your guard. It implies the information is already known and your confirmation is a formality. It isn't. The correct move. Here is line 2. Whether you are at your door, on the street, or in any non-custodial encounter, say clearly, "I am exercising my Fifth Amendment right to remain silent." Then stop talking. If they continue asking, do not answer. Do not fill the silence. Do not explain your situation, your history, or your family. Simply repeat, "I am exercising my Fifth Amendment right to remain silent." Note one important legal boundary. You cannot lie to a federal agent. Lying to federal officers is a criminal offense under 18 U.S.C. Section 1001. You do not have to speak, but if you do speak, do not provide false information. The correct move is always silence, not fabrication. Bottom line, never answer questions about your birthplace, immigration status, or how or when you entered the country. You are not legally required to answer. The Fifth Amendment protects that silence for every person, regardless of status. Mistake 3, not asking whether you are being detained. The mistake? ICE is outside. You haven't let them in. You haven't answered questions. But they're still there. They're still asking. They stand between you and your car. They follow you down the sidewalk. Minutes pass. You stay because you're not sure if you're allowed to leave. And that uncertainty, that silence, works entirely in their favor. The scenario. You step outside to leave for work. 2 agents approach. They say they need to verify your identity. You say you don't want to answer questions. They keep standing there, asking follow-up questions, blocking your path casually. 5 minutes pass. 10. You've stayed the entire time because no one told you that you could leave. But here's the legal question nobody asked. Am I being detained? The legal reality. Under Terry versus Ohio, 1968, law enforcement can briefly detain a person if they have specific, articulable facts suggesting criminal activity. But a consensual encounter, where you are free to walk away, requires no legal justification at all. The problem is that agents rarely tell you which category you're in. Florida versus Bostick, 1991, established that the proper question is whether a reasonable person would feel free to leave. If you never ask, and you never try to leave, a court may later view the encounter as entirely voluntary, which gives agents far more latitude than a formal detention. The correct move: ask directly and clearly. Am I free to leave? Ask it calmly. Ask it once. If the answer is yes, leave immediately. Don't explain where you're going. Don't say goodbye. Walk away calmly. If the answer is no, you are now being detained. At that point, say clearly, "I do not consent to this detention, and I wish to speak with an attorney." Then stop talking. You've created a legal record. If the detention was unlawful, if agents lacked reasonable suspicion, your attorney will have documented grounds to challenge it. Why it works. This single question forces the agent to commit to a legal position. Either you are free and the encounter ends, or you are being detained and the Constitution's protections fully engage. The body cam footage or any witness present will show you asked. That matters enormously in any future legal proceeding. Bottom line, never assume you have to stay. Always ask, "Am I free to leave?" If yes, leave. If no, stop talking and request an attorney. Mistake 4. Not asking for an attorney immediately upon detention or arrest. The mistake. ICE has told you that you are not free to leave, or they've placed you under arrest. Your instinct is to explain yourself, to tell your story, to prove that there's been a misunderstanding. So you talk, you answer questions, you provide information. You think that if you can just make them understand your situation, they'll let you go. They won't. And everything you've said is now part of your case. The scenario. You've been detained. An agent says, "If you just tell us what we need to know, we can figure this out." He sounds reasonable. He seems like he wants to help. So you talk. You explain your timeline. You mention family members. You describe your living arrangements. You sign a form he hands you because he says it's just a formality. Weeks later, you're in removal proceedings. The form you signed was a voluntary departure agreement. The information you gave was used to locate someone else. Your statement was used to establish your immigration history. All of it happened because you didn't say the one phrase that stops this process cold. The legal reality. Under immigration law, you have the right to speak with an attorney before answering questions, though, unlike in criminal proceedings, the government is not required to provide one for you in civil immigration matters. However, the Supreme Court held in Matthews v. Diaz, 1976, that due process protections apply to non-citizens in the United States. You have the right to seek legal counsel and, critically, you have the right not to sign anything without that counsel present. ICE agents are not required to give you a Miranda warning during a civil immigration encounter. That means they can ask you questions and use your answers against you without the warnings that apply in criminal custody. The only protection you have is the one you invoke yourself. Why people don't do it. People think asking for an attorney makes them look guilty. They think cooperation will lead to leniency. They think they can explain their way out. But in immigration proceedings, there is no explaining your way out of documented admissions. Your words on record are permanent. And never sign anything. Voluntary departure forms, waivers of rights, documents you don't fully understand. All of them carry legal consequences. Signing a voluntary departure form, for example, can result in a formal record of removal and future bars to re-entry. You have the right to refuse to sign until you have spoken with a lawyer. The correct move. The moment you are detained or arrested, say this clearly: "I want to speak with an attorney before answering any questions." Then stop talking, completely. No explanations, no clarifications, no small talk. If they hand you documents, say, "I do not want to sign anything without speaking to an attorney." And mean it. Do not sign anything. Why it works. This invocation puts the legal burden back on the system. It creates a documented record that you asked for counsel. It stops the information gathering process. And it preserves your options in any subsequent immigration hearing. An attorney can assess whether your detention was lawful, whether any statements you made under pressure can be challenged, and what legal pathways remain available to you. Bottom line, the moment you are detained, stop talking. Say you want an attorney. Say you will not sign anything. And repeat those two things until you have legal representation. The 4 phrases. One more time. Here's the truth about an ICE encounter. It is not a conversation. It is a legal interaction where every word you say, every door you open, every document you hand over, and every question you answer can be used to build a case against you or someone you love. The Constitution does not reward cooperation with ICE. It rewards knowing exactly what to say and, more importantly, exactly what not to say. Here are the 4 phrases. Memorize them. Write them down. Put them somewhere accessible. Line 1. I do not consent to you entering my home. Use this the moment ICE comes to your door without a judicial warrant signed by a judge. Line 2. I am exercising my 5th Amendment right to remain silent. Use this for any question about your birthplace, immigration status, or history. Line 3. Am I free to leave? Use this anytime you are unsure whether the encounter is voluntary. If yes, leave. If no, move to line 4. Line 4. I want to speak with an attorney before answering any questions, and I will not sign anything. Use this the moment you are told you are being detained or placed under arrest. 4 phrases. That's it. Stay calm, stay polite. Do not run. Do not lie. Do not physically resist. Use these phrases and stop talking. Write them down and keep them somewhere you can reach quickly. Not because you are guilty of anything, but because in high-stress moments, when your heart is racing and the stakes are everything, you will not have time to think. You need these phrases ready and automatic. This is educational content only, not legal advice. Immigration law is complex, varies by circumstance, and changes rapidly. Every person's situation is different. If you or someone you know is facing an immigration enforcement situation, contact a qualified immigration attorney immediately. Organizations such as the American Civil Liberties Union, the Immigrant Legal Resource Center, and the National Immigration Law Center maintain resources and referral services for people in urgent situations. If this breakdown helped you understand your rights, share it with everyone you know, your neighbor, your family, your community, because these rights only protect you if you know they exist. The smartest people in these encounters are never the ones who talk their way out. They're the ones who know exactly what to say, exactly what not to say, and exactly when to stop. Stay informed, stay protected. Know your rights.